SwayamPrabha. Digital India. Educated India.
Namaskar students and welcome to Swayam Prabha. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing this course on Bharatiya Nyaya Sanhita 2023, the Substantive Criminal Law. Today we will discuss in session number 19, Offences against Property. So students, in our 18th lesson also, we talked about certain offences against property such as theft, extortion, robbery, dacoity and dishonest misappropriation of property. So, in theft, there is dishonest intention and there is taking of movable property without the consent of the person in whose possession the property was. In extortion, there is delivery of property. Okay. When there is some sort of an immediate force used, immediate threat against the person, then either theft or extortion may amount to robbery. And when such robbery is done by a minimum of 5 number of people, then it amounts to dacoity. Thereafter, we move on to dishonest misappropriation of property, in which there has to be a movable property. The possession of property might be innocent, but it is at the time when the dishonest intention develops that misappropriation of property takes place. So, we discussed the statutory provisions relating to theft, extortion, robbery, dacoity and criminal misappropriation. Today, let us discuss some more offences against property. So, first let us discuss some illustrations relating to criminal misappropriation of property. So, dishonest misappropriation of property has been defined under section 314 of the Bharatiya Nyaya Sanhita. There are certain illustrations appended to explanation 2. What it says is, A finds a rupee on the high road, not knowing to whom the rupee belongs. A picks up the rupee. Here, A has not committed the offence defined in this section. See, why has he not committed the offence yet? Because as it is, he has not developed any dishonest intention regarding that property. Illustration B. A finds a letter on the road containing a bank note. From the direction and contents of the letter, he learns to whom the note belongs. He appropriates the note. He is guilty of an offence under this section, because if he could figure out who the note belonged to, so at least he could have made some efforts to return it to the owner, or at least when he was clear about this thing that this is not something which does not belong to anyone, how could he use it as his own? Then illustration C. A finds a cheque payable to bearer. He can form no conjecture as to the person who has lost the cheque, but the name of the person who has drawn the cheque appears. A knows that this person can direct him to the person in whose favour the cheque was drawn. A appropriates the cheque without attempting to discover the owner. So, A is guilty of dishonest misappropriation of property here. Then, A sees Z drop his purse with money in it. A picks up the purse with the intention of restoring it to Z, but afterwards appropriates it to his own use. A has committed an offence under this section. Similarly, A finds a purse with money not knowing to whom it belongs. He afterwards discovers that it belongs to Z and misappropriates it to his own use. So, A is guilty of an offence under this section. Next illustration, A finds a valuable ring not knowing to whom it belongs. A sells it immediately without attempting to discover the owner. So, A is guilty of an offence under this section. See students, what is the gist of the offence of criminal misappropriation is that there has to be a dishonest intention. Okay. Dishonest intention to use some property as your own, something which is not your property. So, even in cases of lost property, what happens? You are not aware who this property belongs to. But this thing you are aware of is that it does not belong to you. So, something that doesn't belong to you and still you appropriate that property for your own benefit. So, that in itself amounts to dishonest misappropriation of property. Now, section 315, now this talks about a peculiar circumstance, that is, suppose a person dies and suppose the person has some property on his person. He might be wearing certain rings, might be carrying a wallet, a watch or anything else, something that is in the possession of that person when that person died. Now, since that person has died, he no longer retains possession over that property. So, in case somebody removes that property from his person, now what does that offence amount to? So, section 315 of the BNS provides an answer to this. What does it say? Whoever dishonestly misappropriates or converts to his own use any property knowing that such property was in the possession of a deceased person at the time of the person's decease and has not since been in the possession of any person legally entitled to such possession shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine, and if offender at the time of such person's decease was employed by him as a clerk or servant, the imprisonment may extend up to 7 years. So, you see, it would not amount to theft, because in theft what is required is that you have to remove the property out of the possession of a person without that person's consent. But since the person has died, so that property is not in his actual possession anymore, and that person is not even in a position to give his consent or to refuse his consent. So, herein the offence of theft cannot be constituted, but it would nonetheless be dishonest misappropriation of property. See, there is an illustration. Z dies in possession of furniture and money. His servant A, before the money comes into the possession of any person entitled to such possession, dishonestly misappropriates it. So, what has A committed? The offence which has been defined under section 315 of the BNS, that is dishonest misappropriation of a property which was possessed by a deceased person at the time of his or her death. Moving on, section 316 talks about the crime of breach of trust. See, for breach of trust, there first has to be a trust between two people, and it is only when such a trust which exists between these two people is breached by one of them, it is only then that there can be a criminal breach of trust. What does section 316 say? Whoever being in any manner entrusted with property. So, you see, the first ingredient for 316 is that there has to be an entrustment with property. Now, property could be of any kind. It could be movable property, it could be immovable property. But what is necessary is that there should be two people who have some sort of a trust between them, a relationship of trust, and it is on account of that trust that one person entrusts his property, whether movable or immovable, to that other person. So, whoever being in any manner entrusted with property or with any dominion over property, here we are talking about immovable property, so dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract express or implied which he has made touching the discharge of such trust, or willfully suffers any other person so to do, commits criminal breach of trust. So, suppose you are going out and you ask your friend to take care of your house in your absence, and you also allow the person to stay in your house if the person wants to. But what that person does, the moment you are out, he puts in some people from whom he is drawing a rent to use your premises or your house. Now what does that amount to? Criminal breach of trust, because you had entrusted that person with dominion over your property and that person was supposed to take care of that, and at the most if he wanted to spend a day or two, he could have done that. But when he turns that into a money making enterprise for himself, he is leasing it out or he is renting it out. So now what has he done? He has breached the express direction that he was given at the time of entrustment of that property. Sometimes such directions might not be express, but they might be implied also. So this all depends upon the level of trust and the kind of entrustment between the parties. See, there is an explanation. A person being an employer of an establishment, whether exempted under section 17 of the Employers Provident Funds and Miscellaneous Provisions Act or not, who deducts the employee's contribution from the wages payable to the employee for credit to a provident fund or family pension fund established by any law for the time being in force shall be deemed to have been entrusted with the amount of the contribution so deducted by him, and if he makes default in the payment of such contributions to the said fund in violation of the said law, shall be deemed to have dishonestly used the amount of the said contribution in violation of a direction of law as aforesaid. Explanation 2 further says, a person being an employer who deducts the employee's contribution from the wages payable to the employee for credit to the employee state insurance fund held and administered by the Employee State Insurance Corporation established under the Employee State Insurance Act 1948 shall be deemed to have been entrusted with the amount of contribution so deducted by him, and if he makes default in the payment of such contribution to the said fund in violation of the said act, shall be deemed to have dishonestly used the amount of the said contribution in violation of a direction of law as aforesaid. So you see, it is very clear that if there is a deduction which the employer is entitled to make on the salary of the employee, now that salary has not been paid to the employee, and the employer before paying the entire salary keeps a deduction to himself. Here you cannot say that there is not a specific entrustment of the property, because it is not that first the employee gets the money and then he gives it to the employer for safekeeping. No. Here the salary is something which belongs to the employee, and once the employer has made a deduction in respect of suppose state insurance or for provident fund, now he is supposed to deposit that money in the employee's fund only, and if he does anything, if he does not do it in the manner as prescribed by the law, then that is a breach of the trust, and that would amount to criminal breach of trust. Look at the illustrations. A being executor to the will of a deceased person, dishonestly disobeys the law which directs him to divide the effects according to the will and appropriates them to his own use. So what has A committed here? Criminal breach of trust. Then A is a warehouse keeper. Z, going on a journey, entrusts his furniture to A under a contract that it shall be returned on payment of a stipulated sum for warehouse room. A dishonestly sells the goods. What has A committed here? A breach of trust. A is residing in Kolkata and he is an agent for Z who is residing at Delhi. There is an express or implied contract between A and Z that all sums remitted by Z to A shall be invested by A according to Z's direction. Z remits 1 lakh of rupees to A with directions to A to invest the same in company's paper. A dishonestly disobeys the directions and employs the money in his own business. So A has committed criminal breach of trust. But if A, in illustration C, not dishonestly but in good faith believing that it will be more for Z's advantage to hold shares in the Bank of Bengal, disobeys Z's direction and buys shares in the Bank of Bengal for Z Instead of buying company's paper here, though Z should suffer loss and should be entitled to bring a civil action against A on account of that loss, yet A, not having dishonestly, has not committed criminal breach of trust. So, students, in this illustration, why is the accused not guilty of criminal breach of trust? Because he lacks the dishonest intention. He did not do it with the intention to deliberately cause loss to the other person. See, in criminal law, it is very, very important to see what is the mens rea that has been prescribed to constitute a particular crime. Whether it is dishonestly, fraudulently, intentionally, voluntarily, knowingly, but there has to be some kind of mens rea associated with the crime in order to constitute criminal behavior. Otherwise, it could be civil offence, but it would not amount to criminal behavior unless and until the law has expressly declared it to be a strict liability offence, in which case we do not pay heed to the requirement of mens rea in such offences. Next illustration, A revenue officer is entrusted with public money and is either directed by law or bound by a contract, express or implied, with the government to pay into a certain treasury all the public money which he holds. A dishonestly appropriates the money. A has committed criminal breach of trust. A carrier is entrusted by Z with property to be carried by land or by water. A dishonestly misappropriates the property. A has committed criminal breach of trust. Now, what is the punishment? The law says whoever commits criminal breach of trust shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. And then there is an aggravated degree of breach of trust. What is that? Whoever being entrusted with property as a carrier, wharfinger or warehouse keeper commits criminal breach of trust in respect of such property shall be punished with imprisonment of either description for a term which may extend to 7 years. So, in cases of ordinary criminal breach of trust, the punishment is 5 years. In case this is committed by a carrier, wharfinger or warehouse keeper, the punishment is 7 years. Then, whoever being a clerk or servant or employed as a clerk or servant and being in any manner entrusted in such capacity with property or with any dominion over property commits criminal breach of trust in respect of that property shall be punished with imprisonment of either description for a term which may extend to 7 years again, and shall also be liable to fine. Then, whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in way of business as a banker, merchant, factor, broker, attorney or agent commits criminal breach of trust in respect of that property shall be punished with imprisonment for life or with imprisonment for either description for a term which may extend to 10 years. So, depending upon the gravity of the crime, the proportion of the punishment also keeps increasing. Now, what does stolen property mean? What amounts to stolen property? Section 317 of the Bharatiya Nyaya Sanhita defines it. It says, property, the possession whereof has been transferred by theft or extortion or robbery or cheating, and property which has been criminally misappropriated or in respect of which criminal breach of trust has been committed is designated as stolen property. So, you see what can be stolen property? Not only that, what is literally stolen or literally the subject matter of theft. Any property which is the subject matter of extortion, cheating, criminal breach of trust, misappropriation of property, in all these cases any property which has been acquired by such means would be known as stolen property. So, it could be any property, it could be movable, it could be immovable. Then, whether the transfer has been made or misappropriation or breach of trust has been committed within or without India, but if such property subsequently comes into the possession of a person legally entitled to the possession thereof, then it ceases to be stolen property thereof. Whoever dishonestly receives or retains any stolen property, knowing or having reason to believe the same to be stolen property, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Suppose somebody comes and gives you a gift and you know that this is a gift which is a stolen property, or somebody leaves something at your place and you know that it is a stolen property. So now that is, you have received or retained such stolen property which you should not have done. You should have informed the authorities. And if you do not do that and you retain that property, you receive that property despite knowing that it is stolen property. See here, what is protected is an action done in good faith. But if you had the knowledge that this is a stolen property, and despite that if you retain it, if you receive it, so that in itself is a punishable offence, and the punishment is up to 3 years of imprisonment. Then, whoever dishonestly receives or retains any stolen property, the possession thereof he knows or has reason to believe to have been transferred by the commission of dacoity, or dishonestly received from a person whom he knows or has reason to believe to belong or to have belonged to a gang of dacoits. Property which he knows or has reason to believe to have been stolen shall be punished with imprisonment for life, or with rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. So any property which is stolen property and that you receive, which you know from one who is a dacoit, or anyone who earlier belonged to a gang of dacoits, and you know that this is a stolen property, despite that if you get that property, then the punishment is a very high punishment which may extend up to 10 years. So whoever habitually receives or deals in property which he knows or has reason to believe to be stolen property shall be punished with imprisonment for life, or up to 10 years. So this is habitually receiving or dealing in property which he knows to believe to be stolen property. Whoever voluntarily assists in concealing or disposing of or making away with property which he knows or has reason to believe to be stolen property shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Now coming to the crime of cheating. What amounts to cheating? Section 318 of the Bharatiya Nyaya Sanhita says, whoever by deceiving any person, okay, when you have committed deceit on a person, fraudulently or dishonestly, that is with the intention to defraud a person, or with the intention to cause a wrongful gain or a wrongful loss to a person, induces the person so deceived to deliver any property to any person. See, not necessarily to himself. When the other person is induced to deliver the property to any person, it could be him, it could be anyone, any third person also, or to consent that any person shall retain any property. Okay, the property is already lying with someone, but if you commit a deceit or with a dishonest intention, you induce a person to consent that okay, this property shall be retained by that third person, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit to do if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person, and the damage could be in body, mind, reputation, or property, is said to cheat. So here what is very, very important is that either damage should have been caused, or there should be a likelihood of a damage being caused, and the damage could be in mind, body, reputation, property, it could be any kind of damage, but the act should have the capacity to have either actually caused damage or which is likely to cause damage. A dishonest concealment of facts. See, sometimes you have a duty to speak out, and when you have a duty to speak, if you don't speak out, that amounts to a dishonest concealment of facts. So sometimes when you lie and you misrepresent something which you know is not true, that is also a dishonest concealment of fact. And sometimes when you don't speak out, when you are under a duty to speak, that would also amount to dishonest concealment of fact. So, such a dishonest concealment can take place expressly or impliedly. But what is important is it should be a dishonest concealment. That is, the act should be such which has the capacity of causing a wrongful gain to someone and a wrongful loss to someone else. So, a dishonest concealment of facts is a deception within the meaning of this section. Let us look at the illustrations. A, by falsely pretending to be in the civil service, intentionally deceives Z and thus dishonestly induces Z to let him have on credit goods for which he does not mean to pay. Now see here, had it not been for that deception, he would not have got goods on credit. But this person has done that, and at the same time he does not even have the intention to pay. So it means that he has a dishonest intention. He intends to cause a wrongful gain to himself and a wrongful loss to the other person, and he has also misrepresented himself to be in the civil services, something which he is not actually. So here what has A committed? The crime of cheating. Second, A, by putting a counterfeit mark on an article, intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer and thus dishonestly induces Z to buy and pay for the article. Illustration C. A, by exhibiting to Z a false sample of an article, intentionally deceives Z into believing that the article corresponds with the sample and thereby dishonestly induces Z to buy and pay for the article. A, cheats. Moving further, illustration D. A, by tendering in payment for an article a bill on a house with which A keeps no money and by which A expects that the bill will be dishonored, intentionally deceives Z and thereby dishonestly induces Z to deliver the article intending not to pay for it. So, you see there is a dishonest intention herein. So, A cheats. Illustration E. A, by pledging as diamonds articles which he knows are not diamonds, he intentionally deceives Z and thereby dishonestly induces Z to lend money. This is cheating. Illustration F. A intentionally deceives Z into a belief that A means to repay any money that Z may lend to him and thereby dishonestly induces Z to lend him money. A, not intending to repay it. A, cheats. Illustration G. A intentionally deceives Z into a belief that A means to deliver to Z a certain quantity of indigo plant which he does not intend to deliver and thereby dishonestly induces Z to advance money upon the faith of such delivery. A cheats. But if A at the time of obtaining the money intends to deliver the indigo plant and afterwards breaks his contract and does not deliver it, he does not cheat but is liable only to a civil action for breach of contract. So, students, you see in illustration G, it is clear that what would amount to a crime and what wouldn't, unless and until there is a dishonest intention present to cheat. Till that time it would not be a criminal behavior. See, at the time of entering into the contract, the person did not have any dishonest intentions not to perform his part of the promise. But suppose later on he is not able to perform his part of the promise, so that would amount to a breach of contract, which will entitle the other person to initiate civil action against this person. But no criminal charges would be attracted in such a case. Illustration H. A intentionally deceives Z into a belief that A has performed A's part of a contract made with Z which he has not performed and thereby dishonestly induces Z to pay money. A cheats. Then illustration I. A sells and conveys an estate to B. A, knowing that in consequence of such sale, he has no right to the property, sells or mortgages the same to Z without disclosing the fact of the previous sale and conveyance to B, and receives the purchase or mortgage money from Z. So, A cheats. Now, what is the punishment for cheating? Whoever cheats shall be punished with imprisonment of either description for a term which may extend to 3 years, and whoever cheats with knowledge that he is thereby likely to cause wrongful loss to a person whose interest in the transaction to which the cheating relates he was bound either by law or by a legal contract to protect, shall be punished with either imprisonment of either description for a term which may extend to 5 years. And whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person, or to make, alter or destroy the whole or any part of a valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years and also fine. Now, we come to cheating by personation. So, section 319 defines the crime of cheating by personation when somebody cheats another person by projecting himself as someone whom he is not. So, what does the law say? A person is said to cheat by personation if he cheats. So, the requirement of cheating has to be there, but how does this person cheat here? By pretending to be some other person, or by knowingly substituting one person for another, or representing that he or any other person is a person other than he or such person really is. So, the offence is committed whether the individual personated is a real or an imaginary person. So, even if you are just projecting yourselves to be some such person who is not in existence, but you have built up in your imagination so as to induce the other person to do something on account of which you or someone else will get a wrongful gain and the person will suffer a wrongful loss. So, even that would amount to cheating by personation. What does the illustration say? A cheats by pretending to be a certain rich banker of the same name. A cheats by personation. See, the name of these two persons is the same, but you are not that banker. But to the other person, you pretend to be the same person who you are not, to be that other banker. And on account of that, the other person enters into some sort of a transaction with you, due to which he suffers some sort of a loss. So, that would amount to cheating by personation. A cheats by pretending to be B, a person who is deceased. So, A cheats by personation. Whoever cheats by personation shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine, or with both. Now, dishonest or fraudulent removal or concealment of property to prevent distribution among creditors. Now, you are supposed to repay loan to the creditors, but just because you do not want them to get back their money, what you do? You dishonestly or fraudulently either remove the property or you conceal the property. So, does that amount to a crime? Yes. Under section 320 of the BNS, what does it say? Whoever dishonestly or fraudulently. So, here it should be either with an intent to cause a wrongful gain or a wrongful loss, or it should be with an intent to commit a fraud. If you remove, conceal or deliver to any person, or transfer or cause to be transferred to any person without adequate consideration. See, if adequate consideration, proper payment has been made, then there is no wrong. The problem is without adequate consideration. See, suppose the consideration is more and if you paid a lesser amount, even that is wrong, because that is not an adequate amount of consideration. So, here what is required is without adequate consideration, any property intending thereby to prevent, or knowing it to be likely that he will thereby prevent the distribution of that property according to law among his creditors or the creditors of any other person, shall be punished with imprisonment of either description for a term which shall not be less than 6 months, but which may extend to 2 years. Then what is mischief? The law defines mischief, whoever with intent to cause. So what is required here is, first, the highest degree of mens rea, which is intention, or knowing that he is likely to cause. Second would be either there has to be an intent or there could be a knowledge. Wrongful loss or damage to the public or to any person. See, even if the damage or the loss is not being caused to any particular person, but if it is being caused to the public property is being damaged, even that would amount to mischief. So what does the law say? The act should be done with intention or with knowledge, and the objective should be to cause loss or damage to either some person or to the public property. Causes the destruction of any property or any such change in any property or in situation thereof as destroys or diminishes its value or utility or affects it injuriously, commits mischief. Explanation 1. It is not essential to the offence of mischief that the offender should intend to cause loss or damage to the owner of the property injured or destroyed. It is sufficient if he intends to cause or knows that he is likely to cause wrongful loss or damage to any person by injuring any property, whether it belongs to that person or not. And mischief may be committed by an act affecting property belonging to person who commits the act or to that person and others jointly. So if there are two people who jointly have some ownership in a property, you deliberately diminish the value of that property so that when you sell it, lesser money will be coming. You are suffering loss to yourself also, but the other person is also suffering a loss on account of your activity. So that would amount to mischief. This would be no ground for exemption from criminal liability, that I have also suffered the loss. That is totally your wish. But when you by your actions have caused someone else to suffer a loss, a wrongful loss, that would amount to a mischievous act. Look at the illustrations. A voluntarily burns a valuable security belonging to Z, intending to cause wrongful loss to Z. A has committed mischief. A introduces water into an ice house belonging to Z and thus causes the ice to melt, intending wrongful loss to Z. A has committed mischief. So you see here some seemingly innocent activities. This is just put water into somebody's ice house, but that has caused the house to melt. That has caused the value of that property to diminish, or it gets destroyed. So that would amount to mischief. But what is important here, that the action should be done intentionally or knowingly. Now if there is a person of sound mind who pours water over ice, of course the law is not going to accept that you did not know that water, when poured over ice, it will cause the ice to melt and thereby it would be destroyed. So either there has to be an intention or knowledge that has to be proven on part of the accused person. Sometimes intention might be difficult to prove, but knowledge, it can be presumed in such cases. Then, A voluntarily throws into a river a ring belonging to Z with the intention of thereby causing wrongful loss to Z. A has committed mischief. A, knowing that his effects are about to be taken in execution in order to satisfy a debt due from him to Z, he destroys those effects with the intention of thereby preventing Z from obtaining satisfaction of the debt and thus causing damage to Z. A has committed mischief. A, having insured a ship, voluntarily causes the same to be cast away with the intention of causing damage to the underwriters. A has committed mischief. Now A causes a ship to be cast away, intending thereby to cause damage to Z, who has lent money on bottomry of the ship. Again A has committed mischief. Now look at illustration G. A, having joint property with Z in a horse, shoots the horse, intending thereby to cause wrongful loss to Z. Here what has A committed? mischief. Illustration H. A causes cattle to enter upon a field belonging to Z, intending to cause and knowing that he is likely to cause damage to Z's crop. A has committed mischief. Now, here can A be allowed to take the plea that, see, what have I done? I have not damaged the crops. But when you have mischievously, with a dishonest intention, you have allowed cattle to enter somebody else's fields. You knew that the cattle are going to damage the crops. That is something which every reasonably sane person is presumed to know. So, if you have done such an act, the law will hold you guilty of the crime of mischief. The punishments. Whoever commits mischief shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. And whoever commits mischief and thereby causes loss or damage to any property, including the property of government or local authority, shall be punished with imprisonment of either description which may extend to 1 year. Then, whoever commits mischief and thereby causes loss or damage to the amount of 20,000 rupees. See where the crime is higher in gravity. Then in such cases where the loss or damage is the amount of 20,000 rupees and more, but less than 1 lakh rupees, then the punishment would be up to 2 years. And whoever commits mischief and thereby causes loss or damage to the amount of 1 lakh rupees or upwards shall be punished with imprisonment for 5 years. Then, whoever commits mischief, having made preparation for causing to any person death or hurt or wrongful restraint or fear of death or of hurt or of wrongful restraint, shall be punished with imprisonment of either description for a term which may extend to 5 years, and it shall also be liable to fine. In addition to this, there are certain other provisions also in the BNS which are relating to mischief by killing or maiming an animal, or mischief by injury, inundation, fire or explosive substance, or mischief with intent to destroy or make unsafe a rail, aircraft, decked vessel, or one of 20 tons burden, and punishment for intentionally running vessel aground or ashore with intent to commit theft. So, now these are specific instances of mischief for which specific punishments have been prescribed under the BNS. Now, let us understand what is criminal trespass and house trespass. See, when you enter into someone else's property without that person's permission, okay, that would amount to trespass. You are trespassing into someone else's boundaries. But then when does such a trespass amount to a criminal trespass? Let us understand that. The law says, whoever enters into or upon property in possession of another. Now, what is important is, such entry was done with intent to commit an offence or to intimidate, insult or annoy any person in possession of such property. So, there has to be some sort of an intention accompanying such act. It could be an intention to commit an offence. Sometimes you know that the person does not want you there, still you are there, so it will cause annoyance to that person. Suppose you want to insult that person, that, see, I don't regard your authority. So, that is in disregard of his authority of possession over that property. So, if you have done that in order to intimidate that person, insult him or annoy him, anyone who is in possession of property, or sometimes what happens, if you have lawfully entered into upon such property, but you unlawfully remain there with intent thereby to intimidate, insult or annoy any such person, or with intent to commit an offence, that would amount to commission of criminal trespass. See, sometimes you might be invited to some place. So, your entry is not illegal, but after you have been asked to make an exit, or if you have been asked to leave, beyond that, if you deliberately stay there with the intent to insult or annoy or offend that person, that in itself would also amount to criminal trespass. Now, what does the law say further? Whoever commits criminal trespass by entering into or remaining in a building, tent or vessel used as a human dwelling or any building used as a place for worship or as a place for custody of property is said to commit house trespass. Now, when the criminal trespass is done at a place where people stay, that is house trespass. That could be a building which is used for living of people, or that could be a vessel, it could be any place which is used as a place for worship or any place which is used for custody of property. This would all amount to house trespass. The introduction of any part of the criminal trespasser's body entering is sufficient to constitute house trespass. Whoever commits criminal trespass shall be punished with imprisonment of either description for a term which may extend to 3 months. So, you see a simple house trespass, simple criminal trespass even without doing any other harm. But if had caused annoyance to the other person, it would also be punishable with imprisonment up to 3 months. And whoever commits house trespass shall be punished with either description or punishment of either description for a term up to 1 year. So, in simple criminal trespass, the punishment is 3 months. In house trespass, the punishment may extend up to 1 year. Then house trespass and house breaking. Now, house breaking means when you attempt to enter into the house through an opening in the house which was either not there or which was not meant to effect entry. Suppose you scale walls to enter into a house, suppose you enter house through a window, or suppose you break it by break open a portion of the house in order to effect your entry. So, that would amount to house breaking. See, what does the law say? Whoever commits house trespass having taken precautions to conceal such house trespass from some person. Now, this is known as lurking house trespass. See, when you try to hide yourselves, when you try to conceal your presence from someone, that is known as lurking house trespass. What it says? Whoever commits house trespass, having taken precautions to conceal such house trespass from some person who has a right to exclude or eject the trespasser from the building, tent or vessel which is subject of trespass, is said to commit lurking house trespass. So, a person is said to commit house breaking who commits house trespass if he effects his entrance into the house or any part of it in any of the 6 ways hereinafter described, or if being in the house or any part of it for the purpose of committing an offence or having committed an offence therein, he quits the house or any part of it in any of the following ways. So, house breaking could be in order to enter the house, house breaking could also be in order to exit the house, but the intention should be either to commit an offence after getting in or to commit an offence after to get out after committing an offence in the house. So, what are the 6 ways in which house breaking is constituted? 1. If he enters or quits through a passage made by himself or by any abettor of the house trespass in order to committing of the house trespass. If he enters or quits through any passage not intended by any person other than himself as an abettor of the offence for human entrance, or through any passage through which he has obtained access by scaling or climbing over any wall or building, that is also house breaking. If he enters or quits through any passage which he or any abettor of the house trespass has opened in order to the committing of house trespass by any means by which that passage was not intended by the occupier of the house to be opened. If he enters or quits by opening any lock in order to the committing of house trespass or in order to quitting of house after a house trespass. If he effects his entrance or departure by using criminal force or committing an assault or threatening any person with assault, or if he enters or quits by any passage which he knows to have been fastened against such entrance or departure and to have been unfastened by himself or the abettor to the house trespass. So, any outhouse or building occupied with the house and between which and such house there is an immediate internal communication is part of the house within the meaning of this section. There are certain illustrations which will further clarify what is criminal trespass, house trespass and house breaking. A commits house trespass by making a hole through the wall of Z's house and putting his hand through the aperture. This is called as house breaking. A commits house trespass by creeping into a ship at a porthole between decks. This is again house breaking, because see, it is a vessel wherein property is stored, some people might also be staying there. Then A commits house trespass by entering Z's house through a window. This is also house trespass, house breaking. A commits house trespass by entering Z's house through the door, having opened a door which was fastened. This is house breaking. Then A commits house trespass by entering Z's house through the door, having lifted a latch, or by putting a wire through a hole in the door. So, this is house breaking. Now, what has he done? He has opened the door in a way in which it was not meant to be opened, and it has been opened by someone who was not supposed to enter the door or open the door. This is house breaking. A finds the key of Z's house door which Z had lost and commits house trespass by entering Z's house, having opened the door with that key. Now, this is house breaking because he was not supposed to enter the house by the usage of that key. So, that would also amount to house breaking. Here we cannot say that, see, he has not broken open any part, he has not unfastened anything, but he has used the key to open a door, something which he was not supposed to do to effect his entry. So, that entry was not meant for him. That in itself amounts to house breaking. Z is standing in the doorway. A forces a passage by knocking Z down and commits house trespass by entering the house. This is again house breaking. Then Z, the doorkeeper of Y, is standing in Y's doorway. A commits house trespass by entering the house, having deterred Z from opposing him by threatening to beat him. So, here it is a threat of assault. This is again house breaking. After this, we come to another chapter of the BNS, which is offences relating to documents and property marks. So, here let us talk about false documents. What is a false document and what amounts to the crime of making a false document? A person is said to make a false document or a false electronic record. See, after the IT Act, in the criminal law also we have introduced all concepts relating to electronic records, electronic signatures and all. So, a person is said to make a false document or false electronic record who dishonestly or fraudulently. So, first condition is either there has to be a dishonest intention or there has to be an intent to defraud. And after that, what are the acts that should be done with such dishonest intention or with intent to defraud? What does the law say? If anyone makes, signs, seals or executes a document or part of a document, makes or transmits any electronic record or part of electronic record, affixes any electronic signature on any electronic record. See, when we talk about electronic record, when we talk about electronic signature, what do we mean by that? Now, electronic records refers to any contract, document or other record created, generated, sent, communicated, received or stored by electronic means. And electronic signature or e-signature is a simple method of signing electronic documents. Unlike digital signatures, they are not cryptographically protected. You simply put your signatures on a blank piece of paper, you scan that signature, you prepare a PDF copy of the same and then you paste it on electronic documents. That in itself is an electronic signature. You have not made any efforts to encrypt that. See, it is different from what we call as digital signatures. These are mere simple electronic signatures. So, whoever with a dishonest intention or fraudulently makes any mark denoting the execution of a document or the authenticity of the document or the authenticity of the electronic signature with the intention of causing it to be believed that such document or part of document, electronic record or electronic signature was made, signed, sealed, executed, transmitted or affixed by or by the authority of a person to whom or by whose authority he knows that it was not made, signed, sealed, executed or affixed, or who without any lawful authority dishonestly or fraudulently by cancellation or otherwise alters a document or an electronic record in any material part thereof after it has been made, executed or affixed with electronic signature either by himself or by any other person, whether such a person is alive or dead at the time of such alteration. And next, who dishonestly or fraudulently causes any person to sign, seal, execute or alter a document or an electronic record or to affix his electronic signature on any electronic record, knowing that such person by unsoundness of mind or intoxication cannot, or by reason of deception practiced upon him, does not know the contents of document or electronic record or the nature of alteration. Then coming to forgery, that is when you forge certain documents. So, that is whoever makes any false document or false electronic record or part of a document or electronic record with intent to cause damage or injury to public or to any person, or to support any claim or title, or cause any person to part with any property or to enter into any express or implied contract, or with intent to commit fraud or that fraud may be committed, commits forgery. Punishment for forgery may extend up to 2 years. Then for aggravated forms of forgery, that is where it is done that such document shall be used for purpose of cheating, punishment may go up to 7 years. If forgery is done with the intention that it shall harm the reputation of any party, then imprisonment may extend up to 3 years. Then there are further more offences relating to forged documents, and then provisions concerning offences relating to property marks. See, property marks are different from trademarks. Property marks deny an ownership of a property. So, property mark is a mark used for denoting that movable property belongs to a particular person. So, whoever marks any movable property or goods or any case, package or other receptacle containing movable property or goods, or uses any case, package or other receptacle having any mark thereon in a manner reasonably calculated to cause it to be believed that the property or goods so marked or property or goods contained in any such receptacle so marked belong to a person to whom they do not belong, then it is said to use a false property mark, and the punishment for such usage is punishment of imprisonment up to 1 year or with fine. Then tampering with property marks, counterfeiting property marks, making or possession of any instrument for counterfeiting a property mark, selling goods marked with counterfeit property marks, making a false mark upon a receptacle containing goods, all these are also crimes. So, students, this is all about property offences. In this chapter and in the previous chapter, we dealt with all the offences relating to property which have been given in the BNS. So, in the next lecture, we will be dealing with certain miscellaneous provisions which we could not deal with in the previous 19 sessions before we conclude this course. I hope you are enjoying the lectures. Thank you.